Anatomy of a Murder. The discussion of the Aarushi story will have Avirook Sen and Tanveer Ahmed Mir in conversation with Geeta Ramaseshan.
And Tanveer, and welcome to Chennai.
Thank you very much.
Nice,
Um,
nice.
all of us, I think, are familiar with the Aarushi case, in the sense that we had such a surfeit of it in the media at one stage, that after some time, like all issues that come and go, the interest waned. And then comes your book, which has, in a way, to my mind, not just written about the two murders and the unsolved questions that remain, but is also a very telling and chilling commentary on the criminal justice system as it is in India today. I mean, those of us who work with the system are aware of this in various ways, and I think over the years, in a way, in a most unfortunate way, I think we also get hardened, and lawyers always say that when a case is lost, they say it's the fate of the client, and they just move on to the next stage. But your book, to my mind, is asking a lot of unresolved issues and questions that actually also show in a very chilling way what can happen to a set of individuals who get involved in the criminal justice system over which they really have no control, you know. And on this premise, let me ask you a very cliched question, but just to say that I understand that this is your first book on a major criminal trial. Yeah? And was there any particular reason you decided on this case, or
Right. First of all, thank you very much, everyone, for coming. And thank you, Geeta and the Hindu, for having me. The question is actually not as easy to answer as you made it sound. It was a process in that I had one great advantage coming to this case, and that was of complete ignorance about it. I knew nothing at all. So I came in fresh. I came in because I was asked by a Bombay newspaper, of all things, the Mirror, to cover the case, the trial, on a daily basis. When I got into it, the little that I had read about the case in the media, I got the impression that this is an open and shut case. It's an open and shut business. So I thought, well, at the trial, this thing is going to be over in a month. I'll be out of here. But as witnesses started coming in, as people were being, they were recording the testimonies, being cross-examined, what I found is that the levels of manipulation, or the levels of, for lack of another word, fraudulent activity that was going on, didn't suggest to me in any way this was an open and shut case, because if it was, then why go through all of that? Then present the case and be done with it. The other, perhaps most significant thing was that Geeta was mentioning that for most of us who are not lawyers, the criminal justice system is an abstraction. It is something that other people go through, not you. Increasingly, while covering the case, I got the sense of it could happen to me, and it could happen to anybody. The third thing about this case, and that's why I think I got sucked into it even more. The third thing is that this case, as it played out, almost like a film before my eyes every day in court and elsewhere, was about us as Indians, who we are, what our value systems are, the kind of mosaic that we have in our country, and the clash of those various Indias. So I write in my introduction that when Rakesh Sharma went to space, the Prime Minister at the time, Indira Gandhi, asked him, so what does India look like from space? And he said, Sare Jahan Se Acha. Beautiful answer, no doubt. This book is about what India looks like from the ground. And that's why I wrote it.
Also, one very interesting aspect of your book is that it highlights what one can face in a regular situation, such as a bias, prejudice, and various other aspects that, a litigant or a accused can face within the criminal justice system. I wanted to ask you two aspects about it. I know for a fact that the thread runs in your book that these two people are innocent, right? And I think that passion and belief is what has actually comes through in the book. You know, whether you intended it that way or not, that's the impression I get. And I'm sure many who read this will also get. So you do make a very strong case for the Talwars. And hopefully the case that you make can help them in the appeal, you know. But of course, knowing how the system works, it's like you take the evidence on record and go. I wanted to ask you yet another interesting aspect that you narrate in this, which I was actually discussing with Tanveer earlier, is the way you describe the trial courts. And the way you describe the bar, the way you describe how man-hours are lost because of strike or because of
Karwa Chauth.
condolence, Kadwa Chauth or any other issues. Most of us are familiar with this in various ways. And how then this is then seen as a delay in the end of the trial. Yeah? So in many ways, I think you have very interestingly taken on the legal system also and the judiciary in more ways than one, but in a very, very, not in what you normally, say in a very aggressive tone, but in a very matter-of-fact journalistic way. I found that interesting, but did you?
And thank you for saying that. So there are two aspects to this. The first is that you mentioned that the theme of the Talwar's innocence, supposedly, runs through the book. I mean, my position on this is different. This is a court of law, it's a court case. So in a trial, in a murder trial, the question can never be whether somebody is innocent or not. The question is quite simply, are they guilty on the basis of the evidence presented? That is, and that's a civilizational principle. It goes back to when illiterate people were writing things on the sand. And the presumption of innocence, therefore, is a guiding principle of all law, I'd say, or intuitively. That's one part of it. So, I mean, you can carry away whatever impression you want about the book, and I'm grateful that people such as you have read it. But really the approach was, can the Talwars be convicted based on what's been produced in court or not? And to me, the simple answer is no, they can't. Because some of the things that have been said in the judgment are either absurd, some others are invented. That's how it's been. Now, to the other aspect of your question was the description of this, like a court or whatever it is. There's a small departure, I mean, which was important to me, which is, when I read court reporting done in mainstream media in India, there is absolutely no color in it, in the sense that it seems as if somebody has taken a typed sheet from a court and reproduced it. Everything has a context. Everything, like if we sit here, this building is white, it's got, there's gate number 2 written there, this is red. I mean, it's important that you place things where they are so that it becomes less of an abstraction and more real to the reader and to yourself. So this is I think more and more, I look forward to mainstream journalism being more aware of context and simple detail. That's the attempt in the book, anyway.
I just have one more question before I go to Tanveer on the nitty-gritty of the case. One is that virtually for all of us knew that this was a trial by media. Yeah, it was at every stage there was a trial by media, and you're very strong on that. And actually, when I did see Nupur's interview on television, I thought, this could be a problematic situation. And you just did it. It was so much in your face that one did watch. But, and sure enough, huge amounts of comments came as to how she should express herself. And we know for a fact that no human being expresses themselves in the same way. But at the same time, we often in courts always talk about the demeanor of the witness. Yeah? Right. But here in an interview, there's no way that a lawyer could have briefed her about the demeanor. And you mentioned that that interview was something that was given to NDTV also in a way worked against her. I mean, would you like to elaborate on this whole trial by media process?
Yeah, so the Talwars actually, before going to any court at all, before being tried, that only happened in 2011 and 12. They went first and foremost, or they were tried first and foremost, in the court of public opinion. And they lost that battle right away with that one interview. I'll give you an example. I mean, I was giving a talk at a law school recently where I played just the audio of that interview. And I asked the students and the professors, can you tell me whether this person is weeping or not, whether there is grief or not on this person's face? What is your perception of the guilt or innocence of this person? And the answers were surprisingly mixed. But the thing about television, the power of it, is that, an impression will set in your head as if it's a seal of some sort. And basically, it's a projection of your own attitudes that you see on TV. So if most of middle-class India thinks this way, if most of middle-class India, unfortunately, suspends its rationality and doesn't look at the seriousness of that charge and goes instead by gut or conduct rather than evidence, this is the kind of tragic consequence you will get. And the media has a huge role to play in this. You mentioned that there was this interview. One of the things, there's another famous case that's playing out at this moment, which is the Sheena Bora murder case, right? If you will have noticed, Peter Mukherjee, when the case initially broke, Peter Mukherjee did not give any visual interviews to the media. He spoke on the phone to all channels. He said whatever he had to, and it could be true, it could be lies, who knows. But he did not give the opportunity to the camera to sit and be judge. And that was the advice given to him by his lawyers. That's how it worked. There's another aspect to this, just to wrap up on the media front. Look, the tools of our trade are simple. And I say this wherever I go. Those haven't changed. You need to attribute, you need to check, you need to verify. And in the end, you need to understand whether it is, whatever it is, even the smallest piece you're writing, impacts in any way public interest. So once you have these simple rules in place, I think you can do decent journalism. You don't have to be Hemingway to be doing this. In the Aarushi case, all of these things broke down, unfortunately. So the leaks, insidious as they were, that the Talwars were throwing, orgies in various hotels, for instance, or they were in some wife-swapping racket, without a shred of evidence, these were carried verbatim. Just exactly how the alleged source told them. I militate against that. It angers me that people in my trade do it. So I'm a sort of a critic of this. It also angers me that they suspend rationality. That if someone tells them, as the public prosecutor did during trial, that DNA gets washed off by alcohol. So Dr. Talwar's DNA was not found on a bottle of alcohol because as he was drinking it neat, his DNA was being wiped off as if it's, some kind of window cleanser that that you can use to wipe off DNA. This is absurd. Nobody asks, for instance, nobody critically asks, and they report as it is, how an expert witness can come and make this claim that erections have a life after death, that they last 48 hours after. I mean, there are doctors in the house, I'm sure, and there are physiological reasons why a swelling can take place. But for God's sake, that's different from an erection. Yeah? If every swelling was an erection, you know what? It would be problematic. Anyway, so that's the kind of thing, yeah.
I think it's also, the fact that, investigation agencies, which is a trend that you see today, plant the evidence in the media, and no questions are often asked. If you recollect Madhumita's case in Uttar Pradesh, yeah, the poet, where all the letters that she had written were shown on television, and you wonder
Guess who was the prosecuting counsel in that one?
And how the evidence gets through into the media when normally under a normal circumstance, a party to the process will have to file huge applications and get them out. Yeah. Tanveer, the book, there's a lot of you in the book, yeah, and in your role as part of the process in the trial. And it's how you went through this, and of course certain legal strategies which all of us know. We do it at that stage and we don't know how this can, how it may play out in a given scenario. But what actually shocked me in a sense was that there was tampering of evidence. There was not bringing in evidence to the court, which would have, left it to the court to decide. There were summons and information that were being given out by one of the investigation officers through an email that was neither the CBI email ID, nor was it his own ID, which as a lawyer we know is not done. You normally get it through a sealed summons, or communications are often given as interrogatories. And yet these kind of overzealousness shown didn't cut much headway. I mean, there is bias according to the materials which the book furnishes. There is prejudice, and we know that these two are always playing itself in the legal system. There's nothing new about that. But the way in which evidence was deliberately tampered is something I would ask you. I mean, what was your impression, and why do you think the court didn't look at all in various ways? Yeah, but then I think people would be interested in knowing that without the technicalities of the evidence part.
First of all, I would like to thank everybody here for inviting me down, and everybody in the audience to come up and hear this conversation. Yes, you're right. To a certain extent, tampering of evidence was there. It was something that I raised in the trial with strong ferocity, and I gave my reasons, I gave my arguments. There was a strong cross-examination, but ultimately it is left finally to the discretion of the trial judge as to how he will deal with critical issues. So, for example, if you see the whole judgment in Avirook's book or otherwise by consumption through, the judgment is available on internet. A lot of people have read it, commented on it. When we reached the stage of final arguments between myself as the main defense counsel and my counterpart, Mr. Saini on the CBI, we agreed before the trial judge that one of the most important witnesses is that domestic help, Bharti Mandal, because she comes to the apartment at 6 o'clock in the morning. It is accepted by us, it is accepted by them. Now, I'd like to say two things here. Bharti Mandal's police statement was recorded on 16th May 2008, on the date when the murders were discovered, murder of Aarushi was discovered in the morning. She gave a statement. Then her statement was recorded on 2 occasions again by CBI investigators. When she came to the court, she gave an altogetherly new anecdote over and above her previous statements. In the cross-examination, she was confronted, and then, we asked her questions. She said that what I've said in the court, I'm saying for the first time. I have not said this before. She also said in very plain Hindi language, I'll also translate it in English. She said, मुझे जो सिखाया गया है, मैंने वही बयान अदालत में दिया है. So in English, if we translate it literally, whatever I have been taught is what I have stated in the court. Now, when we went into the phase of final arguments, I raised an argument that the statement which this witness has made in the court goes to the root of the matter, gives the matter an altogetherly different context, plus the witness candidly admits that she has been tutored. The line of statement that she has given clearly favors the prosecution. So this witness is not credible for taking out any conclusions. The trial judge, whilst writing the judgment, if I'm correct, on page 72 of the judgment, says that I agree with Mr. Mir that witness Bharti Mandal has testified pursuant to tutoring. But I am still willing to believe this witness because she's a bucolic woman coming from lower strata of society. Now the question is, when you ask about tampering, now tampering in comparison with this kind of a finding which I can only term as a colossally egregious finding, because by no stretch of imagination can any trial judge, either in New Delhi or in New York, or even in a monarchy, forget a democracy where, we are ruled by law, by statutes. You can't say that I am going to believe a witness because the witness belongs to this particular society or that particular society. So the judgment, as a matter of fact, this Aarushi Talwar Hemraj double murder judgment is a judgment of its own sorts. Usually the judges, if they write, say, a 500-page judgment, in first about 150 pages, they'll only write about fact submissions. They'll not give any findings. The Talwars, as a matter of fact, are convicted in para number 2. The remaining is a rhetoric. So to that extent, when it came to exercising discretion, now, for example, we raised the issues of tampering with evidence, these pillow covers and all that thing, the swapping of pillow covers, or, somewhere the CDF, the laboratory also in Hyderabad, giving a new report over and above a first report and then saying that there is a typographical error, was far less than this finding. That is why in my appeal, which is pending before Allahabad High Court, the first and more issue that we raised before the appellate court is that whether the honorable judges of a constitutional court are willing to sustain a finding where the trial judge says that I'm going to believe a witness on the basis of the strata of society that witness belongs to.
There's one aspect which, both of you we can discuss on that, is the way honor was constructed in this case. From the time the UP police gave a media interview, the very beginning, by saying that it was honor crime, to the way in which, though honor as a terminology was not used very frequently, but the whole thrust of the prosecution was that, they were found, the late Aarushi and Hemraj were found within courts in a compromising position. That's the legal language, pardon me for that. Yes. Though I think much stronger language comes through later on. and the father in a fit of temper saw and then killed. Now to me, you know, looking at the way in which one way to see this seemed incredible in the very beginning itself, because here was a 14-year-old, assuming that there was a kind of a misbehavior on the part of the late Hemraj. You were actually looking at a case of child abuse, and any parent, even the so-called parents who do not belong to the class of you know, the Talwars, but belong to, say, some other segment within quotes of society which the judge describes, would then immediately react in a way in which they would protect the child and, you know, proceed or seek any other kind of recourse against, against Hemraj. I mean, this would be the normal reaction, at least in the recent times when one is reading so much of child abuse. But nowhere along was this taken note of, but on the contrary, you have this huge construction of honor as if the child was a major woman of so many years taking a decision on her own, and like the Khap Panchayats, there was an attack on her. It was very disturbing in many ways because, you know, it only implied that, and then the application of the last scene theory in the house, the application of the fact that the sound was not heard by them, which is what they said, and it can happen to many of us. I mean, thieves, there's burglary in your room and a offender can be standing next to you because you don't hear the noise. Yeah? So, you know, it's shocking that none of these could ever come with the way the investigation proceeded, and honor was sought to be constructed.
So actually, Geeta, I mean, we touched upon this before. It filters down, it boils down to, not filters down, boils down to the attitudes prevalent among the magistrates and investigators of these courts and these places. I'll give you an example. I was mentioning a little while earlier that you tend to, as human beings, everyone does that, project your own set of beliefs on others. This is precisely what happened in the Aarushi case. The gentleman who actually crystallized the honor killing theory is somebody who was a forensic scientist sitting in Gujarat. I mean, he's the one who wrote at length about it. And it was him, it was this gentleman, who, by the way, has a track record of dreaming up scenarios. He's done it in the past, in the Godra case, for instance. And he happens to have a cultural context, which he has been, according to his colleagues who have spoken to, unable to shed. Now, I've been called casteist and racist and stuff like this as a result of this, but he does come from an area, born and brought up in an area, where honor killings and khap panchayats are common. So, yeah, I mean, so you want to add to that?
You see, ultimately, you can have particular opinions about particular people coming from anywhere and perceiving things. But when you go to a court of law, ultimately it is the evidence that is to be tested. Now this whole thing that was set up, that this 13-year-old girl, which she was about 8 days lesser than being 14, being allegedly found in a compromising position with a grandfather of a domestic help, leading to a situation where, as per the CBI case, the father got enraged. Well, actually, a lot of people don't believe, don't know it, is that, you know, this whole honor killing compromise is based on a very huge mistake, which was clearly brought out by us during the course of the trial. But our misfortune is that the honorable judge simply brushed it aside and didn't have a look at it. Now, I'll have to just take 1 minute to elaborate. The CBI investigators came on the Talwar household for the first time on 1st June 2008, along with a huge team of forensics from the CFSL Delhi, in order to collect evidence of whatever was left at the apartment after the Noida police fiasco in not being able to even secure the crime scene. Now, importantly, at that point of time, they seized about 57 to 58 exhibits, which includes a pillow and a pillow cover, which is actually, if you finally look at that piece of evidence when it was produced before the court, that bore a tag that this pillow and pillow cover has been seized from Hemraj's room. It bears a date, a signature of the director of CFSL, and one investigator of CBI. Now, when an inventory was prepared by CBI officials in their offices, they wrongly wrote in a column that this pillow cover is seized from Aarushi's room. Now, this pillow cover had Hemraj's blood. So, the investigators gave these documents to Dr. Dahiya, and Dr. Dahiya inculcated this account of there being some kind of an alleged, sexual intercourse going on, compromising position of whatever was thought, and completely based it on the presence of Hemraj's blood on a pillow cover found in Aarushi's room. Now, the investigators were so callous that before they supplied this information to the forensics, they did not even check. The forensic also did not check, physically see the documents or call for any other DNA reports, serology reports. And in the heat of the moment, in what the investigators wanted them to believe, or firstly what they believed themselves, a huge report was made. That came as a crime scene analysis of Dr. Dahiya. Now, to the misfortune of CBI, this pillow cover, for the first time when it was opened in the court, it bore a tag. Now, this happened during the cross-examination of one Dr. Mahapatra, who had done a DNA analysis. Now, everybody was shell-shocked. So we thought that the main case of Dr. Dahiya is gone. And he had no premise to stand on in view of his findings based on this piece of evidence. This was taken to the court during the course of final arguments, but unfortunately, the court didn't even buy it at all.
See, Tanveer, the thing is that evidence becomes irrelevant when rationality is suspended. I'll give you an example. The same court, I mean, you would know about it, and a lot of you may also know about the Nithari killings, which took place in the same general area. Now, that case also had two parties, a master and a servant, and eventually they were both convicted by a lower court for the killings and rapes and various other ghastly things that they did to a number, more than a dozen children. Now, the lower court, the same court in fact, not the same judge, it convicted the master against whom there was actually not a shred of evidence in terms of real evidence, on the basis of a statement given to the court by the servant. The court was told by Surinder Kohli, who was a servant in this case, that when I saw my master drink whiskey, liquor, and engage with prostitutes, and all the debauchery that was going on in the house, what would happen to me is that my, within quotes, animal instincts would get aroused. And these murders that I, that I participated in were as a result of the arousal of my animal instincts. Now, the learned judge then posited this testimony like so. He said, all right, in that case, had the master not been a drunk and a debauch, the murderer's animal instincts would not have been aroused, and therefore, the murders would not have taken place. Thus, the master is equally guilty. This man is put away for 7 years. He's broken. Thankfully, when the evidence was read again, at least the higher court did the justice of pointing this out, that this leap from debauch to murderer needs something called evidence in between. You know? I'll point to some of the, I mean, Tanveer spoke at length, I think, about some of the technical aspects of this case, but the social ones are just as important. I mean, what are our attitudes like? One example. One of the things that I mentioned early on that the Talwars lost in the court of public opinion straight away. How did they lose this battle? They lost it because they were cast in what I'd call in a role in which they found themselves to be the other. People who we don't really want to mix with. That kind of person. How does this happen? This happens through rumors such as wife swapping rackets, you know, pornography that they, you know, they were regularly, yeah. So once again, the evidence points somewhere else. But just how deep this runs is palpable or is evident in the smallest parts of this case. In one testimony which has been recorded by the CBI officer, in one testimony which is recorded by the CBI officer, a friend of Dr. Talwar says that at Dr. Talwar's parties, Dr. Talwar would throw parties, fair enough. Sure. Liquor would be served at these parties, fair enough. And non-vegetarian food would be served even though it was Thursday. Now, what are we talking about? Are we talking about what happened on that day? Or so this sort of suspension of what I'd say rationality and the appeal to your own sense of conservatism, this runs through this case, page after page, in anything that you read about it. And that is why it is, you know, it tells me at least more about India than anything else that I've encountered. I mean, this, like Geeta said, this is playing out every day. But these things are not, for me, an abstraction anymore. I've seen it happen. And like I said before, it could happen to you.
Just a last comment question before we take questions from the audience. Having constructed the theory of honor, the prosecution then asked for the death sentence. Yeah? And then the court reduced it to life imprisonment. Now, if there was a theory of honor constructed which provoked the parents to then, kill their child, where was the question of asking for death sentence? Was it not provocation?
Look, I think it's a fixed match, is how I look at it. Because the
I
moment...
I just wanted to,
I mean, Tanveer will probably elaborate much more and better.
Yeah.
But in my view, very, very briefly, it's this. It's that, in fact, if you read the judgment, the judge leaves no room at all to give anything but death. Because he calls these people freaks of nature. Very seldom in the history of humankind, he says, have people like this, you know, arrived on this earth. In that case, it must be rarest of the rare, which is like your guiding principle. Then why not death? Why not death? Because death gets referred or gets escalated to a higher court really quickly. Life, on the other hand, in this case, is slow death. And that's what was given to the Talwars. This is what I think. I mean, Tanveer will probably...
Well, again, you know, speaking purely from a court perspective, making a submission on the point of sentence is always the prerogative of the counsels at bar. So a prosecutor may come up with a submission of death sentence, but it is up to him how he wants to substantiate that. I was not bothering much about it because I knew already that there is a battle on my hands. But let me tell you that the same judge, you see, there was a lot of evidence. For example, in the servant's room, there was a Sula wine bottle consumed almost. There was a beer bottle. There was a soft drink, 2-liter soft drink bottle. There were 3 glasses. The witnesses whose testimonies were recorded earlier had all said this categorically. Later they changed their statements. But the judge, again, in his own discretion, had his own willingness, own desire to give a finding. So what a finding did he give? So I said that, if Your Honor, I committed the murders, so what happened to these bottles? Who consumed this liquor? Why is the blood of the servant on the bottles? Doesn't it show presence of other people in the apartment? He says, no, Mr. Mir. You see, after you committed double murders, you had a bottle of Sula wine, you had a bottle of beer, you had 2 liters of Sprite, but yet you were not smelling foul in the morning.
Valentine's whiskey also.
Yeah, and Ballantine's whiskey, which was on. So when it comes to returning findings, it is up to the trial court. But we have a system. You see, there are not. For example, let me give you an example to closing before we throw it for general public. We have a humongous criminal case in Parliament attack. It happened before my eyes, and I very closely followed the trial. It was in my own court. So the trial court judge gave 3 death sentences and 1 5 years imprisonment to the lady. When the matter went to High Court in death reference and appeal, it was 2 acquittals. When it went up to the Supreme Court, virtually 3 acquittals. So again, what was debated is that where the trial judge had to find evidence, he wrote about 200 pages on how terrorism affects the world. But you can't convict somebody on how terrorism affects the world. So similarly, the judge certainly has convicted my clients, and he has given his reasons. Those reasons are up in challenge, and according to us, that judgment is not sustainable. And that's what we are arguing before the Allahabad High Court.
And good luck to you on that. So maybe take a few questions from the audience, please. Is there a mic going on?
Three of you were remarking about the trial court judges. You are remarking about the trial court judges. When in the High Court there is a bench, the Supreme Court in the bench, why can't in the trial court itself there is a bench to hear these important cases, and afterwards they can go to a bench in the trial court itself? Why can't
I'll take that. I think it's difficult enough to find one competent judge in the trial court. You're talking about a bench. It's a lot.
Anyway, that's...
So what is the safeguard that you would suggest? Do we go back to the jury system? Do you think the jury would have been better? But with the jury, we had the Lakshmikanthan murder case in Chennai about 50, 60 years back, when 2 of the top stars in Tamil Nadu were originally convicted by the Madras High Court, went to the Privy Council remanded the matter back. When they came back to the Madras High Court, they were both acquitted. So, I don't know. Jury system also has not proved to be very effective. So what would you suggest are the improvements in the system which can stop things like this from happening?
Well, that's a question for which we would need a lot of time for a debate. But yes, at the end of the day, the legislature provides us a system for the purposes of adjudication in a court of law. You have a system where there is a prosecution, there is a defense, and then there is a well-trained judge. Now, you can say that whether you go back to the jury, but at the end of the day, the jury can always be overruled by the judge. And the jury has its own limitations in understanding finer aspects of acceptability of evidence. So I'm not an advocate for the cause of getting the jury back into a trial system in India. I still firmly believe that we are certainly better off with well-trained judges, but we have to accept that judges are also human beings, and they are as fallible as anybody can be. So therefore, there is a system that you go to a trial court first, then you go to a court of appeal. Now, what everybody can understand is that every person who is convicted by a criminal court has a fundamental right of first appeal. Now, the appellate court is under an obligation to reappreciate every aspect of evidence afresh, as if the trial court judgment never was there. And the trial court judgment has to be shelved for the time being when the appellate court looks at the evidence. So that way, there is a double system of check. And I think that we can certainly build on that rather than thinking about going back to a system where there are juries, because that has its own complications as well.
I think as a aspect is the fact that a book like this, you know, we need to probably, it really demystifies a case, deconstructs it as well as demystifies the system. And one, you know, a start can be that more serious books are written about criminal cases of this nature.
Hello?
I have not read the...
Sorry.
Is somebody
Yes.
else talking? I've not read the book myself, but I really wanted to be here because this was one case I followed both as a parent, as a person who works with CSA. My point is, one is the base instincts that are being aroused because of non-vegetarian, which happens to be the political statement also that beef eating is now causing more rapes in India. But how does the judge who sits in the trial court face an accountability later on? Is there a system in which the judge pays for any form of a wrong judgment?
See, you cannot have a system where you can have an accountability for a judge for a wrong judgment, because our system provides immunity to judges from because a judge would always write a judgment in good faith, you know, taking into his account and appreciating the evidence, and then, you know, his inner conscience telling him that yes, I must acquit these people or I must convict these people. But accountability is something which is far-fetched. But now you have Avirook's book, and, you know, frankly, you know, kudos to Avirook. After the judgment was passed, the trial judge is now a lawyer in Allahabad High Court along with his son. And he went and had a conversation with both of them, and which he has on a tape as well. And parts of those conversations are in his book. And, you know, in that conversation, the lawyer's son says that I traveled from Allahabad to Ghaziabad a month before to assist my father in writing the judgment. Now, there is, you see, a charter of 1997 adopted by the Honorable Supreme Court full bench, which is called as Restatement of Judicial Ethics and Judicial Life, then adopted by a full court Chief Justice's Conference in Bangalore in 1999, in consequence of which every High Court judge and every Supreme Court judge, now if you just click onto the internet and you go to the High Court website, you're able to see their assets. Now, guideline number 4 of that Restatement of Judicial Ethics states that no judge shall allow any kith or kin, son or daughter or any relative being a lawyer, to get associated with him in any cause that he's adjudicating. So therefore, the accountability comes from something, you know, which Avirook has done in this case, which is impossible in other cases. And based on this, you know, we've already prepared an application. We say that there is serious miscarriage of justice in this case, and there is violation of Supreme Court guidelines, because now we cannot be certain of the fact that that feeling on part of the trial judge to convict the Talwars, whether that was his independent feeling or whether it got influenced by interaction with another lawyer. So to that extent, in my opinion, the judgment stands completely vitiated. But to that extent, we have to again follow the procedure of law, which means that we have to file an application in the appellate court in the pending appeal and get Avirook to testify and prove his conversation.
One question to Mr. Avirook. Only one question to Mr. Avirook. One. Okay, go ahead.
Sir, honor killing is out of the question. What you said is a fit of temper. Honor killing has got a lot of explanations and context. And the media trial should be there, you know. Otherwise, nobody takes it seriously. But what I'm asking the author is, why did you select the book? Did you find anything wrong with the media trial? Or you want to tell a new truth? Or did you think it was sensational, but people made a film and it was a super flop? but one biggest foreign director came with millions of dollars. They didn't give him rights, but somebody got rights. Why did you write the book? Because it was sensational, or you wanted to do justice to Aarushi?
Okay, so this is a rather large question, and I'm not even sure I'm qualified to answer it. I wrote the book basically because that's what I do. I'm a writer.
The question to the panelist, some of the inferences what I'm getting is little disturbing because, as you said, the conviction of a convention of his conservatism influences the arguments or even the evidences. Is it an exception to the rule or it is reflects on the total Indian legal system?
It's not just the Indian legal system, sir. I don't think it is. Because the Indian legal system does not, it may appear to be in a bubble or a cocoon, but actually where do these people come from? They come from the same stock as you or me. So don't exclude that. So I've been told it's a wrap. So what I'd say is that it doesn't exist in a vacuum. It's there everywhere. This underlying conservatism in Indian society is there everywhere. You find it in the media, in the police, in the bureaucracy, in politics, and in fact among judges and lawyers. So.
Can we take one last question?
That will be the last question, please.
So just a general question. How much does celebrity factor play a role even with judges? Because a few years back I was covering a case, not a big one, but then the High Court lawyer was arguing for a few days, and then one of the parties decided to bring in a Supreme Court lawyer, and when the Supreme Court lawyer came in, till that point the judge wasn't willing to give an adjournment, and he said you'll have to finish arguments the next day. But then the next day they brought in a Supreme Court lawyer, and the judge himself seemed too very overawed to see the Supreme Court lawyer, and he gave an adjournment immediately. And we know what happens with big cases. We still don't know who drove Salman Khan's car. So do celebrity factor does it play a role even with probably trial court judges? I'm not too sure about high court judges, but are trial court judges sort of overawed? And we also see, big celebrities get away. People with, for example, Sanjay Dutt as well has jumped. So is that sort of a factor that sort of plays on the minds of judges?
Well, I think I said this before that, you see, judges are also human beings. They're not robots. So if I'm amenable to influence, if I am amenable to apprehension, so will be the person who will be the presiding officer. Yes, to a certain extent, when a matter gets seriously sensationalized, then the tendency of the judges somewhere is to be more cautious. But within that caution, the call of the duty is that you have to be true to the evidence, you have to apply your mind, and why, celebrity or something is a part of the game. You can't take the celebrity out of the society because we make them celebrities. And definitely, behind somebody's acquittal or conviction, there are reasons. Now, the larger perspective is how the investigation is carried out. Now, ultimately, you see a person like Salman Khan, today we are all saying that the car was driving on its own. So the question is that ultimately, it is the prosecution's case that is to be tested by the trial court. Now, trial court can't invent evidence.
Thank you very much. And Avirook and Tanveer, and good luck to your appeal.
Thank you very much.
Thank you, ma'am.
Thank you for coming. Thank you.